In the world where truth is silenced and injustice walks freely, we choose to speak. This is not just a channel, this is the voice of justice where every word is for the truth, and every story, a fight for what's right. Buckle up everyone, because today's case is a legal roller coaster you won't want to miss. We've got constitutional rights colliding with modern technology, a defense attorney fighting tooth and nail to keep this trial off YouTube, and a judge who isn't afraid to push back. The stakes? A defendant facing charges of injury to a child, possible prison time, and questions of fairness in a world where every trial can be streamed, shared, and dissected online. Will broadcasting this trial compromise justice, or is transparency the higher priority? And just wait until you hear the twist: motions denied, dramatic objections, and a last-minute plea deal that changes everything. This courtroom showdown isn't just about one man, it's about how justice works in the digital age. Let's dive in.
All right, I'll see you all for jury trial tomorrow at 9:30.
You had said if we had any pre-trial motions to bring those up.
Yes.
All right, Judge. So I had filed a motion back in August, motion to prohibit the YouTube broadcast of all the legal proceedings.
And I don't have that motion. It's not in the court's file. We're gonna have parties announced for the record for the state.
Anna Ochoa Nelson.
Defense.
Alex Scharf for Mr. Diller.
All right, defense, your first motion.
Yes, Judge. The first motion is the motion to prohibit the YouTube broadcast of all legal proceedings in Mr. Diller's case. The basis for that is that he's got a constitutional right to a fair trial. And by broadcasting what happens during the trial sets up great room for error to happen. As you're aware, the court previously had a trial where one of the witnesses, the complainant, admitted to watching the YouTube testimony of at least another witness.
And you do realize that that complainant testified first, correct?
Yes, Judge.
Okay.
But just for example, that was a main witness and she admitted to watching YouTube. I'm concerned about witnesses watching YouTube. I'm concerned with potential jurors watching YouTube or asking friends or family to watch it for them. And so I'm just really concerned that Mr. Diller won't get a fair trial.
Now this is where things get really interesting. The defense is raising a point that hits at the heart of modern courtroom drama. Does live streaming justice on YouTube actually jeopardize justice itself? Think about it. Witnesses could tune in, jurors could secretly watch, and even friends or family could slip key details back to those testifying. It's the ultimate spoiler alerts problem in a trial. And remember, the Constitution guarantees every defendant a fair trial. But here's the dilemma: should transparency and public access outweigh the risks? What do you think? Would you side with the defense here, or do you believe live streams make justice stronger?
I don't think the news cares about that. But if a juror were to see that, or a witness or one of the witness's friends, then they could let that slip out when the court has already ruled on that issue.
So you're okay with the media coming in filming, is that correct?
I don't have an objection to that.
Okay.
I don't have it. In the motion on page 2, paragraph 5, I want to waive that paragraph because I do believe the court has changed the YouTube channel and does not allow chatting any further. And so I will waive that. I'm also concerned that there's an alleged victim who is a minor. And under the Texas Constitution, Article 1, Section 30A1, that person has a right to privacy, and that by broadcasting it, her name will be revealed. And also, whenever the jury is picked, their names are called out loud, and that's supposed to be done secretly.
All right, is there anything else with regards to your motion, counsel?
Well, the main focus is the concern for Mr. Diller getting a fair trial based on only the evidence that is presented in court and not broadcast or archived videos of earlier proceedings that are watched by potential jurors and potential witnesses.
Okay,
And that's just too huge a risk.
all right. And this is your only pretrial motion?
No,
All right, so that motion is denied. What's your next motion?
I haven't filed it yet. It's ready to be filed. I can hand file it.
And just like that, the judge denies the motion. This is a big moment. The defense laid out a laundry list of concerns: fairness, witness contamination, even juror exposure. But the court isn't buying it. This sets the tone. Transparency is here to stay, at least in this courtroom. For Mr. Diller, though, this denial is huge. It means every word, every pause, and every slip of the tongue could be broadcast to the world. Imagine the pressure. Viewers, if you were in his shoes, would you want your case live streamed to thousands of strangers, or would you fight to keep it private?
Whatever motion you want to file. All right, and see if he can have that heard and let him know that this is scheduled for jury trial tomorrow. So perhaps if he can hear it in the morning, and that way we can move directly into jury trial. Is there any other motion?
Not for today, Judge. Like, we'll probably have a motion in limine whenever.
All right, you may want that heard because technically you have not filed the motion to recuse yet.
Right, you are right.
So,
You are right. Well, I can file it electronically when I get back to the office, or I can hand file it.
well, either you need to file it now. If you don't file it now, then we will hear other motions.
All right. Original 3 copies.
All right, and Ms. Ferguson, see if Judge Harl is available to hear that today, and we will be coming back here on the 17th for trial.
Whoa, did you catch that curveball? The defense just asked the judge to recuse himself. That's basically saying, Judge, you can't be fair here and we need someone else to handle this case. This is not something attorneys throw around lightly. Asking for recusal can signal deep distrust, and it adds a whole new layer of drama. Will another judge agree to step in, or will this request backfire, making the current judge even less sympathetic to the defense? This move shows just how desperate the strategy has become. Viewers, do you think this was smart lawyering or a risky gamble?
And as soon as we got the new court date for
Just one
today,
second. Everyone in the box, please whisper. Yes, you may continue.
and so when I let Mr. Diller know, his wife chimed in immediately. I cannot be there the April 8th through the 10th. She'll be back from a conference that's mandatory for her employer, which is Southwest Research. She'll be back tomorrow, probably late in the afternoon. What's that? 8 p.m. tomorrow.
Okay.
But she's a crucial defense witness. In the motion, I outlined what I expect her testimony to be. I have interviewed her, and I have also attached an affidavit that details what her expected testimony is. She is a crucial witness for the defense.
All right, so here's my thing. You're saying she'll be back on tomorrow by 9 p.m.?
Yes, that's
All right,
expected.
so we would do jury selection. If your case is going, we'd do jury selection today. And I don't think the state is going to finish with their case, or they may be finished with their case in one day on Wednesday, but she probably will not need to be here till Thursday.
Then, I mean, then that would obviate. the
All
need
right,
to
so
read
there's no
that.
need for the motion for continuance?
Well, if the court is gonna work around the schedule,
I mean, if you're telling me that she will be back on April 9th,
be back to 10.
the 10th, if she'll be back on the 10th by 9 p.m., if her testimony is needed, it will be needed at the earliest on the 11th. So there's no need for a motion for continuance? Is that correct?
Well, I mean, I'm not, I'm just saying she can't, if she wasn't here yesterday, she can't be here today, and she won't be here till tomorrow night.
Well, it appears that her testimony is not going to be needed if you wish to call her until April 11th. So are you withdrawing your motion for continuance?
No, Judge, as I mentioned in the beginning, we have started talking about possible resolutions to the case. And broached this subject with him, but I really need her here to discuss things with her too. since they're married.
Well, I
and they
think
have a
you all
child.
better get on the phone, because if you still want to proceed on this motion for continuance for these reasons, the motion for continuance is denied. So y'all need to pick on the phone and call her if that's what you all want to do.
So then when would you want us back to start?
And if you want to speak to your wife, I suggest you all call her on the phone, because once this jury trial starts, it's starting. It's not stopping in the middle of trial because you all have worked something out.
Here we go again. Another motion, another denial. This time the defense argues for a delay, claiming a key witness, the defendant's wife, can't make it in time. But the judge isn't having it. Instead, he works the schedule around her return, essentially stripping the defense of its excuse. Notice the pattern. The court is clearly signaling that this case is moving forward, no delays, no sidesteps. For the defense, it's a tough blow. For the prosecution, it's momentum. And for us watching, it's a reminder of how courtroom timing can be as strategic as the evidence itself.
Bodily injury intentionally and knowingly, that's a third degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your
Did you
Honor.
understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? Court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine.
Yes, Your
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of injury to a child. They're recommending deferred adjudication, and there's to be no contact with the complainant. Did you understand that to
Yes,
be
Your
the
Honor.
plea?
Yes, Your Honor.
Defense?
Yes, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. Did you understand that was a recommendation from the state, and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Yes, Your Honor. State offers states 1 and attachments.
Any objection?
No objection.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. The court has considered states exhibits 1 and attachments, which includes the stipulations. Is there any other evidence either side wish to present to the court before the court makes a ruling on sufficiency of the evidence?
Yes, Judge, Mr. Diller would like to make a brief statement.
All right, yes, Mr. Diller.
Yes, Your Honor. I grabbed her arm.
All right. And I'm assuming the grabbing of the arm caused pain. Is that correct?
Yes.
All right, is that yes?
Yes, Your Honor.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication.
And there it is, the turning point. Instead of rolling the dice on a jury, Mr. Diller pleads no contest. For those unfamiliar, that means he isn't admitting guilt, but he's also not fighting the charges. Legally, it's treated like a guilty plea for sentencing. Why do defendants do this? Often it's about damage control. With the risk of 10 years in prison looming, a deal with deferred adjudication suddenly looks a lot safer. The strategy here is clear: minimize risk, avoid prison, and try to move forward. But it also raises a question: would you take the plea or fight it out in front of a jury?
In fear about fighting this case, and he would do it if he had to. This plea agreement, we believe, is in the interest of all the parties. Mr. Diller will not have contact with the complainant in the future.
Okay. Are you employed?
No, Your Honor.
So how do you support yourself? Are you an SSI or something?
I filed for the, I got denied for the original one because I have too many resources available to me because of my wife's income. Now they're doing the disability part of it, and I think they're at 95% right now.
All right. All right, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's to be no contact with the complainant, proof of employment or SSI within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Regular reporting by Zoom or in person. Regular random UAs. And due to your medical, are you on any type of medications?
Yes, Your Honor.
All right, you'll need to let probation know what those medications are, and you'll need to do a release from your doctor so they can make sure that those medications are being taken as prescribed. You understand? Bill visit one time per month for 3 months. 100 hours of community service restitution. If you would like, you can pay those off at $7.25 per hour. I always recommend the food bank because they always need help. But if there's another charity you would like to donate that to, just ask probation and they'll let you know if it's an approved charity.
Yes, Your Honor.
All right. Probation, and we'll do anger management. Probation, is there anything else?
Okay.
Is there anything else you need from the court to be successful? All
No,
right,
Your
I
Honor.
understand that you have some medical issues that may preclude you from employment.
Listen closely here, this is where the hammer comes down. 6 years of deferred adjudication, strict probation conditions, no contact with the victim, and heavy restrictions around employment and minors. Add in random drug tests, anger management classes, and over 100 hours of community service. This isn't just a slap on the wrist, it's a full lifestyle overhaul, monitored by the court. And here's the kicker, if Mr. Diller violates any of these terms, the court can revoke probation and sentence him to years behind bars. That's the constant sword hanging overhead. Do you think this balance rehabilitation versus punishment hits the mark?
Date for
Just one
today.
second. Everyone in the box, please whisper. Yes, you may continue.
And so when I let Mr. Diller know, his wife chimed in immediately, I cannot be there the April 8th through the 10th. She'll be back from a conference that's mandatory for her employer, which is Southwest Research. She'll be back tomorrow, probably late in the afternoon. What's that? 8 p.m. tomorrow.
Okay.
But she's a crucial defense witness. In the motion, I outlined what I expect her testimony to be. I have interviewed her, and I have also attached an affidavit that details what her expected testimony is. She is a crucial witness for the defense.
All right, so here's my thing. You're saying she'll be back on tomorrow by 9 p.m.?
Yes, that's.
All right,
expected.
so we would do jury selection. If your case is going, we'd do jury selection today. And I don't think the state is going to finish with their case, or they may be finished with their case in one day on Wednesday, but she probably will not need to be here till Thursday.
Then, I mean, then that would obviate.
All right, so there's no need for the motion for continuance?
Well, if the court is gonna work around the schedule,
I mean, if you're telling me that she will be back on April 9th,
be back to 10.
the 10th.
So let's recap. The defense tried to block YouTube coverage, denied. They tried to delay the trial, denied. They even tried to remove the judge, denied. In the end, Mr. Diller entered a no-contest plea to a reduced charge and walked away with 6 years of deferred adjudication and a long list of probation conditions. This case shows us two things. 1, the court's push for transparency in the age of live streaming, and 2, the delicate balance between protecting victims and giving defendants a path to redemption. Now it's your turn. What do you think? Was justice served here, or was this too light a sentence? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Because every truth deserves to be heard, and every injustice will be exposed. This is your voice of justice. Stay with us, with the next story is coming soon.